morning we are going to hear arguments beginning with State of Ohio versus Allen Bugg. That's case number 17CA0087M. The appellant, of course, may reserve up to 5 minutes for rebuttal. Each party will have 15 minutes for their arguments, and they are videotaped, so please keep your voice up during your argument. The court has read the briefs, and we are ready to proceed when you are.
Thanks, Your Honor. I'd like to reserve 2 minutes for rebuttal. May it please, and Ronald Sking on behalf of the defendant, Allen Bugg. May it please the court, Your Honors, you've read the briefs. This appeal consists of one issue. It's kind of a unique issue in regards to testing the blood, the case law, as well as the statutory construction, which occurred after State versus Mall in 2005. Basically, this is a situation where there was 2 suppression hearings. The first suppression hearing involved the chromatography blood draw. Actually, the motion was for all blood tests, but there's really no evidence put on with regards to the hospital test. Based on that fact, there was a second motion to suppress dealing with that specific issue with the hospital test. And as indicated in the brief, the first suppression hearing was granted. The blood draw was suppressed due to the fact that there was not a solid anticoagulant pursuant to 3701, 5305. So the second test really involves, and it's unclear. I would admit that this is a very unclear, very unique set of circumstances when you have this, because on the one hand, 451119 D1A enables a hospital test to be admitted with expert testimony. And I think conceptually that's diametrically opposed to a situation like this, and I found no cases addressing this issue where you have a suppression. Normally you have the hospital test and it's admitted with expert testimony, but I found no cases where you have a test where the gas chromatography test, which is the forensic test, is extremely accurate, extremely reliable, is suppressed, and then you have on the other hand the hospital test, which is, for lack of a better term, very unreliable, coming in its place.
Well, very unreliable, counsel, in whose estimation? I guess what I'm saying is, isn't that what you're challenging, the reliability of
I am. You're absolutely correct, Your Honor. And it would be just, and I'll be frank, I mean, in a particular case, in a perfect world, maybe the defendant could have been an expert to use this, but in reality, all we had was the Julia Warman, who is a scientist who's 34 years in the blood testing field. She's obviously degreed in that, in chemistry or something to that effect. And the testimony that she provided, and I think I outlined that in my brief, where she outlined what this machine, the colorimetric / enzymatic test, tests for. This is a hospital test, it's not a forensic test. And it produces, as indicated in the brief, the coenzyme NADH. And I know that I use the longer term in there, I can barely pronounce it myself, but that's the coenzyme that it produces. And she clearly was very knowledgeable about this subject matter. She knew what NADH was, she knew how it was tested for, how the colorimetric process worked, she knew the specific wavelength of 340 nanometers. Shine through example. She's familiar with Beer-Lambert's law, which is the scientific concept or the chemical concept of how the light is shined through the sample and measured on the other side, the difference between going in and going out. She knew all these things. She's very, very well knowledgeable or very well aware of how this process works. And she also indicated that when I asked her about other things in the body that could produce that same coenzyme, and as I demonstrated, is lactic acid, which could be produced in a car accident, which is what exactly occurred in this case.
Well, counsel,
Might you be arguing weight versus admissibility?
Yes, I know what you're saying, but I think I also addressed an issue in my brief that State versus Burnside kind of sets forth the procedure with regards to how these suppression hearings go. If you're going to, you must challenge the blood testing at the suppression level. There's no question about that. Otherwise, you waive the state laying the foundation. State will not have to lay a foundation at trial if you do not raise that issue. Now, what I've raised in my brief is State versus Burnside, and then this court's decision. I know it's kind of a hard decision to find. Tomco, which is this court ruled on in 1999, which kind of expands on that, and it really outlines the procedure that you need to follow when you're going to challenge these types of tests. And what it is that when you raise the motion of substantial compliance, the state needs to meet its burden of substantial compliance with the test.
So are you conceding then, or telling us that what you raised with regard, I'm going to call it the hospital's test, or your second motion,
Yes.
was that a substantial compliance issue that you raised?
Procedurally, you have to, that's how it's, from the case law that I have, has to be raised. You have to question the test, you have to challenge the test. The state, in turn, has to show some substantial compliance. I will admit in this case, given 4511 D1A, that has been eliminated due to the fact that they after State versus Ball, they changed that. So that as it stands, they don't have to show substantial compliance. Then the burden shifts to the defendant to show that how, if any, he was prejudiced, and that's where I cite State versus Tomco, which says that prejudice, which they define as scientific inaccuracy, unreliability, invalidity, anything that would result in those specific findings being inaccurate. So so when you raise the issue, they show substantial compliance, or they don't have to show substantial compliance, and then the burden shifts to the defense to show that they're going to be prejudiced by that. And that's what I raise in this particular case, where I'm saying the test, the colorimetric enzymatic test, is not accurate. And the state, that's their test. And the witness, when questioned with regards to the accuracy of the test, didn't have an answer, which, you know, I find a little disingenuous when you know all these things about the test, and then when it comes down to, you know, whether or not you can differentiate between what produces NADH, either lactic acid or alcohol, well, gee whiz, I just don't know. But it's clear that you can't distinguish, you can't differentiate the test. And I know that the state has argued in its brief that at one point in the questioning, early on in the questioning, she indicated, well, that shouldn't affect the test. But then clearly after the questions that I've asked at the suppression hearing, clearly indicated that wasn't the case. So she tried to, I guess as a maneuver, try to say, oh, well, that doesn't affect the test. But then I started asking more specific questions about the test, and she had to concede, in particular, that lactic acid caused by muscle or oxygen deprivation of muscles was going to produce lactic acid that would be produced by a car automobile accident, which actually occurred in this case, and that you wouldn't be able to differentiate between those two. So I know that it's a really, it's a unique issue, I think, in that respect, because, I know I don't address that particularly in my brief, and I don't know if it's a legal argument or not, but I'm just saying that there's a gap, there's a disconnect between 4511 D1A and Burnside, Mall, all those cases. There's a disconnect because if you have a case like this, which is rare, right? I think you get the chromatography test thrown out, and you have this hospital test. You really have you have the test, which is, frankly, Your Honors, if the state trooper who has the blood kit in their car, in their trunk, gives that to the hospital, it's over. Game over. It's done. That test is bulletproof. And that's how accurate that chromatography test is. Well, that test wasn't done properly, and that test is out. So now you have this other test that's going to come in where you don't even have to comply with those regulations. And I understand that, but I'm just saying, look at it's very ironic where you're using a very inaccurate test to, in a case like this, to determine whether or not this individual has a concentrated alcohol over 0.08. So
I understand why you felt the need to challenge us through a suppression. And that may very well be, but I'm wondering, would you have been precluded from also filing a Daubert hearing request? Because I kind of almost get the feeling that that's what you're asking us to decide here, to make that reliability kind of finding that a trial court would normally be the first one to make.
perhaps. I mean, probably at the time I didn't think of that. I was more, to be honest with you, at the time when I filed these motions, maybe that would be a proper course. I'm not precluding that at all. I mean, really, I was just trying to address the issue of suppression and follow like the procedure as set forth. But maybe you're right. I mean, maybe that a reliability hearing could have been an issue. But really, what I was trying to follow is just the case law and how it dictates where you can challenge the reliability and the accuracy of this test once the state meets its burden. So I know it's unique, I know it's different. I would just say in closing that I know the state is arguing plain error. I would disagree with that assessment in the fact that this is the procedure they set forth. You know, you substantial compliance, you prove it, and then you can challenge the reliability of the test that way. And that seems to be, you know, from French, Mall, and then more specifically in Akron, in Tomco. So, in closing, Your Honors, I would say that the test is inaccurate. Just by the testimony of Julie Worman, there was no other evidence presented at the hearing which would indicate that this test was testing or indicating what it was supposed to be testing. The NADH can be produced by lactic acid or alcohol. There's no way of discerning that or making that distinction. So therefore, I believe that that test should have been precluded or suppressed at trial. If there's any other questions.
All right, thank you.
Thank you, Your Honor.
You got about 3 minutes and 12 seconds for rebuttal.
Thank you, Your Honor.
Good morning, Your Honors. May it please the Court, I'm Vince Vellucci with the Medina County Prosecutor's Office for the appellee of the state of Ohio. I will start out with it's the sole assignment of error. I'll start with the standard of review. Plain error was mentioned, and I think that is the appropriate standard of review here because this is a completely different argument that's being made on appeal than what was made before the trial court. Nothing like this was argued in front of the trial court. It may have been implied by Mr. Skingle's questions somewhat to this medical technologist during the suppression hearing, but it was never actually argued in a motion or a brief. At trial, the issue was, did the blood test comply with the OAC regulations? On this appeal, he's essentially conceded that point, that not only did it comply, the state didn't have to show substantial compliance under this 451119. I think, and that's a major concession that really narrows down the issues here. So that section applies because the blood sample was withdrawn and analyzed at this Lodi hospital. That's why this 451119 applies, and we don't have to show substantial compliance as a state of Ohio. So it's his burden to show that he was prejudiced by the test. It's not the state's burden. Nothing from this second suppression hearing whatsoever supports Bugg's argument that the colorimetric chemistry test is unreliable. So there's no factual support from this hearing. There's also no legal support for this proposition that this test is unreliable. He keeps making these declaratory statements that the test is unreliable, but there's no support for that. There's no case that holds that. And he didn't present, Bugg didn't present his own expert at this hearing like he could have potentially if he wanted to raise this point and prove that the test is unreliable somehow. But that wasn't done. I think the suggestion that a Daubert hearing would have been more appropriate is right on. This was not even the appropriate vehicle, I think, to raise this.
But if he didn't do it through a suppression, arguably you would have been here today saying he should have done it through a suppression. So I wonder if they're mutually exclusive. I don't know that they are, but
Well, and when you're specifically arguing the reliability of a test, I mean, that's kind of specifically what a Dauber hearing is for. And I think Judge Hensel raises a good point too. You argue this in terms of weight at the trial, that this test should be given limited weight for whatever reason. If you want to present your own witnesses in your defense saying this test is unreliable and so forth. In terms of what actually transpired at the hearing, there was only one witness called. As Mr. Skingle noted, this medical technologist named Julia Warman from the hospital, the Lodi hospital where they did this test. There was no expert of his own called. This was the only person there. The ultimate question that Mr. Skingle asked during this suppression hearing was whether there's a way to differentiate between the NADH caused by the body's reaction with alcohol and the NADH caused by lactic acid that might be caused by an accident and so forth. I guess the body's adrenaline or something of that nature. I'm not a scientist myself, but Ms. Warman, when asked that question directly, basically said she didn't know. That would be a question for the pathologist. Now, Ms. Warman is experienced, I think, according to her testimony. She's been doing this for a while, but the fact of the matter is she's not a physician. She's not a PhD or anything like that, I don't think. She's not a scientist. So I think it's questionable whether she's qualified to answer that question, first of all. So she may not even be, she's certainly not the best person to ask. She may not even be a good person to ask that question to. But even if her testimony is accepted as reliable, just based on her experience or whatever you want to say, I think her testimony actually greatly helped the state of Ohio. She actually says, as Mr. Skingle acknowledged earlier in her testimony, she says, as she understands it, lactic acid doesn't interfere with the test. So that implies that the test can differentiate between these two types of NADH, the type caused by lactic acid and the type caused by alcohol. So I don't think there's nothing at that suppression hearing that supports this point that it's unreliable. As I said, there's no there's no case that has set out that this test is unreliable in any way. Certainly never a case excluding it under Rule 702. There's no case even questioning its reliability in any way, this colorimetric chemistry test. There's no case saying that the probative value is substantially outweighed by the danger of unfair prejudice. Under 403, there's no case holding that. This Tomco case, basically from, I think, the late 90s, it basically just says in dicta at one point that a defendant can show prejudice by showing the unreliability of these test results under all the facts and circumstances. But ultimately in Tomco, the reason I say it's dicta is because that wasn't even the issue. Ultimately in Tomco, the issue was whether, like it was down below in this case, whether the test, it was a breath test in that case, and whether the test complied with the OAC regulations. So ultimately the case wasn't even decided in terms of scientific reliability or unreliability. So Tomco really isn't applicable here. In any event, the holding does not help Bugg's case. It doesn't support what he's trying to do here. So again, legally or factually, I don't think we have support for this test being unreliable. Again, he could have called his own expert at the suppression hearing, could have had a Dauber hearing, could have argued this during his case in chief or in his closing when he's arguing the weight of the evidence. And again, the only testimony that actually did come out, Ms. Mormon, this medical technologist, actually did support the case, the state's position. That's really all I have. If there are any other questions.
Did the expert testify that you cannot differentiate between NADH created by alcohol as opposed to lactic acid or trauma? Was
Well-
that her testimony?
Well, I wouldn't call her an expert necessarily, just because the state called
The
her.
state's witness.
Yeah, we weren't, I don't think she was qualified as an expert, but her testimony was essentially when she's asked the direct question later in her testimony, she says, I don't know, that's a question for the pathologist. But earlier in her testimony, she does say, if you read a little earlier in the transcript, she says, I don't think the lactic acid interferes with the test in any way, as she understands it. So she's almost saying like somebody else told me this or something, like secondhand or something. I guess is the way she phrases it, but it's certainly not helpful to Bugg with what she answers.
All right, thank you.
Thank you.
And you've got 3 minutes and 12 seconds, as I said, for your reply.
Thank you, Mayor. I would just disagree with the state's contention about Tomco. It says, rather, this court finds the issue to be whether the defendant can show any prejudice, including prejudice caused by the scientific inaccuracy, unreliability, or invalidity of the test results under the facts and circumstances. Clearly, the law, the case law indicates that's the procedure of testing or going through this. It's not a plain error analysis. Okay, that's the procedure and how you raise the issue. And then you have to follow that. If not, then you don't just throw out every possible thing that's happened. They have the burden of showing substantial compliance. Once that's done, then you can attack the reliability and accuracy of the test. That's how it works, and that's how it's set forth in Tomco and more generally in Burnside as well as Mel. Now, again, back to the lactic acid. She quoting, first of all, she is a scientist and she is an expert. She has 34 years in the blood testing field. She has a Bachelor of Science degree. In fact, Jeff Trudeau, who testified in the first hearing, also has a bachelor's degree, and he's the main scientist for the Ohio State Highway Patrol. So to intimate that you need a PhD or a medical license to be an expert in this, I think is a stretch. But indicating that specifically what was asked is she interrupted my line of questioning. I said, and oftentimes when that occurs, lactic acid can create NADH. And she says, as I understand, lactic acid doesn't interfere with the ethanol test. That wasn't the question. The question was, does lactic acid produce NADH? Subsequent to that, she indicates that it does. It does produce NADH. And lactic acid is created when muscles are deprived of oxygen and when the muscles sustain trauma in an automobile accident. So yes, she tried to interject herself in trying to protect the testimony of what she's trying to do, but she knew as full as well as when I started asking more specific questions as regarding the production of NADH, she knew where I was going, and she had to adjust her testimony in regards to that fact. So yes, in the end, at the end, she punts and says, well, gee whiz, I don't know. But she didn't say that that wasn't the case. And I think in this particular case, she knows everything about what's going on. And this is the state's test they're going to introduce into evidence. And there's clearly evidence here showing that this test is not accurate. In particular, in conjunction with the gas chromatography test, which has also been suppressed. Because if that's not the case, Your Honors, what's the point of even doing the gas chromatography test? There's no point. Well, why even bother with all that rigmarole with the OAC and the test kit with the troopers? Just use the hospital test. The reason they don't do that is because of these very issues. There's accuracy problems, there's unreliability. Just the fact in and of itself that there is the OAC 3701, 5305, and the gas chromatography test. That's why you have those tests, because they're accurate, they're forensic tests. This is not. And I outlined in my brief, yes, there's not evidence to support some of the rationale why the hospital uses this type of test, but it's clear. It's to determine if there's something in there to prescribe medication or treatment. This is not a forensic test. So, Your Honors, I think, given that fact, and especially in conjunction with the fact that the chromatography test was excluded, and the testimony of Ms. Warner, I think this test was unreliable. I think that the proper procedure was followed at the suppression hearing, and it should have been, the test should have been suppressed.
Thank you both for your presentations today. The court will take the matter under advisement and issue its decision in due course. The clerk of courts obviously will mail you copies of the decision. Opinions are also cited on the Supreme Court's website, so you can check there if you'd like as well.